on the record in the matter of the state of Michigan versus Jessica Stackpool, 241492. And counsel, your appearance, please.
Good afternoon, Your Honor. Christopher Shemke, appearing on behalf of my client. At this time, we consent to the matter being heard via Zoom.
All right, thank you. And Ms. Stackpool, your name for the record, please.
Jessica Stackpool.
All right, and counsel, as to the arraignment.
Wait, formal reading. My client stands mute.
All right, the court will waive the formal reading. Enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on October 24th. And as to bond counsel.
Your Honor, I noticed that in this circumstance, the complainant is her 17-year-old son. She's not on probation or parole. She is gainfully employed. I'd ask that consideration for personal bond be given. And then also, I do believe we need to have some sort of arrangement because the 17-year-old son lives with her, but my client indicates that she could potentially make arrangements for the 17-year-old to go live with my client's sister, the complainant's aunt. But obviously, he can't be staying there by himself as he's a minor. So I'd ask that that just be considered when determining an appropriate course of action. Thank you, Judge.
Okay. So, ma'am, where do you live? I mean, where do you work? I'm sorry, I know where you live here, based upon the police report. Where do you work?
Work at the airport.
Okay, what do you do at the airport, ma'am?
I'm a bartender for a company called
Called what?
La Riche, I think is how you pronounce the second part. La de Gear. It's a food service industry company at the airport.
You've been working there for a year, you said?
I've been on and off at the airport for 13 years now. I just started with this company, I believe it was in June.
Have you ever failed to appear in court, ma'am?
Sorry again?
Have you ever failed to appear in court? I can't hear you, ma'am.
No. No, I haven't.
Are you currently on bond in out of bond in any other jurisdiction?
No.
And are you on probation or parole anywhere?
No, I am not.
Okay, so it appears as though you had a matter in Lincoln Park that was dismissed. That was an assault and battery. Who was involved in that matter with you?
This was my ex-husband.
Okay, and what about the matter for the stalking back in 2017? Who was involved in that one?
That would be him and his current wife.
Okay, and then now we have you being charged with domestic violence against your 17-year-old child, ma'am. And here's what the court's going to order. For the safety of the community, for the safety of Mr. Stackpool, the court's going to, and to ensure that you're going to comply with this court's bond conditions, the court's going to order a $4,500 10% bond. With the following bond conditions. You're not to have any contact with Alexander Stackpool. That's phone contact, text message, email, social media, third party, anything of the like. The only thing that you can do, ma'am, is you may communicate with your sister so that Alexander can stay over there. Where is Alexander's father? Is he in the picture? I'm sorry?
No.
Not at all. He doesn't have any parenting time with him?
I'm sorry, one more time. I'm sorry.
Does your son have any parenting time with his father?
No, he hasn't seen him in 3 years. Mr. Stackpool has not complied with a visitation order.
All right. And the court is going, so ma'am, if Alexander is still at the home, you can't go back there. I'm not saying you can't go back to the home, but you can't have contact with him. So if he's still there and he hasn't gone to live with your sister, then you can't go back to the home. You're not to possess or consume any alcohol or drugs that are not prescribed. You're not to possess or have access to any firearms and or any weapons. Do you have any of those?
No, Your Honor.
And the court's going to also order an alcohol tether through the Wayne County Jail.
Okay.
Any questions, ma'am?
I don't know if I came in with my phone. I don't have my aunt's phone number unless I have access to my cell phone. I don't know her phone number. She lives right in Taylor, but she's unaware that I'm here. I haven't been able to communicate with anybody since I was detained.
Okay, well, hopefully, you will, I don't know what the department's procedure is regarding that, ma'am. But hopefully you'll be able to communicate with your aunt so she can go pick up your son.
Okay.
All right, and then we'll see you back on October 24th.
Okay, thank you, Your Honor.
Thank you, Judge.
Thank you.
Yep. Okay. Go! Will you hand me my screen box? Now go.
Matter of Todd Davis, 232204. And counsel? Mr. Shunky?
Yes, I'm here, Your Honor.
All right, and your appearance, counsel.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client.
Thank you, and Mr. Davis, your name for the record, please.
Todd Davis.
I need you to speak up, please.
Todd Davis.
All right, thank you. I'm recording from the device here, so. Okay, and so this is another adjourned jail review. You were sentenced to 90 days jail on November 16th of 2023. And the court suspended that jail. You participated in random testing. You were doing pretty well, except I'm not sure what's happened this last time since your last jail review on August 20th. We adjourned it for your treatment, I'm showing, and you were to test on August 20th, which shows, I don't show that you tested August 20th. Did you test August 20th?
Yes, I did test.
Well, then it shows you tested positive for marijuana on August 26th. You missed your testing on August 27th, September 13th, September 24th, and October 4th. And then you did provide proof of your intake appointment on September 27th, which was well over a month after you were last here. And you have one more.
Yes, with the intake, I was at Hagera. Their supervisor had went on vacation because the lady who was doing my NA counseling there, she ended up going to another place or whatever. So I had to find a whole new place. I had to take time off of work.
Why'd you have to find a whole new place, sir? If
Because
everything was approved for Hagera, why did you have to find a whole new place?
They wasn't ready for me to, they didn't have the personnel. They did not have the personnel. I had to go
Because
through.
one person left, they didn't have the personnel.
The Santos, it was either wait and not get the treatment that you ordered at one time, or go find another place that did do the treatment. And I think it was better because now I have 3 meetings a week, one with Miss Ashley, who's the coordinator, and 2 Zoom videos a week, Tuesdays and Thursdays with the group.
So how many have you participated in, sir?
This will be my second full week here going into.
All right, it's important to note, sir, that back in November, I ordered you to enroll in outpatient substance use counseling, and you hadn't done that. And now you've been missing testing. Why are you missing your testing, sir? 4. You've missed 4 tests, and then you tested positive for marijuana August 26th.
Well, with the marijuana, I was, Miss Shine, she told me if I had a medical marijuana card when this process first started, that would be honored. So I didn't.
I think that there's a misunderstanding somewhere, sir.
Oh, yeah, there is, because I've been, the marijuana, I smoke daily because of my pain.
At any point, sir,
I gave her proof
to
of
this
my,
court.
yes. With Ms. Shine I have. And I also currently still have my alcohol teller that I've been on since day one. I don't drink, I work
Well,
out.
sir, but here's what, so back on March 8th, my notes show that you found substance use counseling in Lincoln Park, you were having an assessment March 12th here at 1 o'clock. You were to submit 20 job applications per week, you submit those on Monday mornings, okay, and you turn it to April. So now here we are in October, in September, you finally started going to substance use treatment. So I'm not sure why you weren't participating in those.
Well,
Hold on. At one point in April, you were showing proof that you were going. I do not see where you have requested.
this was back in, November when I first got arrested.
Okay, hold on, so it showed you had a valid medical marijuana card.
Yes,
Where, is your medical marijuana card still valid?
yes, ma'am. If I would have known that, I would have brought it with me. I didn't, because me and Ms. Shine had went over
Okay.
that. I didn't know.
Absent that, you missed 4 tests.
Yes, ma'am.
Why?
When I came here on my last review, somehow it was miscommunication, and before I left, you asked me to go next door to the probation to test. Come to find out, Ms. Shine said, well, we don't do testing here. You'll have to go to our.
I ordered you to test today. I didn't say go test in probation. I said go to probation because you're going to test today. That is what I said. Did you go test on August 20th? That was the date you were last in court.
Yeah.
Did you test on August 20th?
Me and Ms. Shine spoke because I told her I didn't have the money. They want $35 now to test. I didn't financially, what am I supposed to go do? Make them drug test me if I don't have the money?
So are you working?
Yes, but that's part-time.
Why aren't you working full-time?
I don't have the transportation and on the days that I do work, I don't have my license. I don't even have, like everywhere I go I am literally walking or catching a bus. I don't have the outlets. I'm barely making my bills. I have $1,400 rent I have to pay. I have to go on that. I have bills. I have a phone bill, and everything is coming on me. And then I come here, and now it's like I get scolded again. And I'm trying my best, ma'am. I am.
Get scolded again, sir.
Yes.
Let me be very clear. Stop, please. Let me be very clear.
Yes.
Okay. You were before this court for an amended charge. You pled guilty to an amended charge of operating while intoxicated. Okay? While intoxicated, second offense.
Yes,
The
ma'am.
driving while license suspended, second or subsequent offense was dismissed completely.
Yes, ma'am.
And then the open alcohol container.
Yes, ma'am.
Based upon those charges and based upon your criminal history that dates back to 2000,
Yes, ma'am.
probation was not recommended for you.
Yes, ma'am.
This court sentenced you to jail for 90 days and suspended that jail to give you an opportunity, sir, to improve your circumstances with judicial oversight. That is what this court did.
Yes, ma'am.
And so when you continue to not necessarily improve your circumstances, as this court is giving you an opportunity to do,
Yes, ma'am.
this court is calling you out on that, not scolding you. There's a
My words,
difference.
yes, I didn't mean scolding, but at the end of the day, I am trying my best in this Santos. And actually, when this first started, I was going through physical therapy, mentally, like I was traumatized behind the actions behind my gun violence case that I had. There was a pattern of things, and there was drinking involved with the domestic violence situation. There was a pattern and I totally turned my situation around. Now the full-time job and the pay that you expect me to, receive and pay for these things, I don't have that right now. I don't have the transportation. There's no one in my household that owns a vehicle. You strip that from me, And not because of.
I did not strip that
No,
from you, sir.
I should-
No, stop.
I apologize.
I did not, please
You
stop,
didn't.
please stop.
You didn't. You
Sir,
didn't.
sir, your actions,
My
actions, whether this court stripped your license, the Secretary of State stripped your license, your actions,
My
or why
actions.
you do not have a
Yes.
license. So that does not get put on
Yes.
anybody else, sir.
No, you're totally right. My actions led me to not, I'm not, I don't have the transportation.
Okay, you still live with your mom, correct?
Yes, ma'am.
Okay, and so, you're paying $1,400 on your own for rent?
Not me personally, no, but I do have to contribute. But
Okay,
after,
sir, of course you have to
Yes.
contribute, but your statement to this court was that you have to pay $1,400 a month for rent. That was your statement to the court, and that's not accurate.
that was
You're
on the
being
record.
disingenuous to the
Yes,
court.
that's on the record, but no, I don't have to pay that. But I do, there's other bills that I have to come up.
Of course, it's
Yes.
part of adulthood, of course
Yes,
it
it's
is.
either that or be homeless, or pay, or take what I have to do this and be homeless. And now I'm homeless, now I'm gonna commit crime. I will be back in these courts and I will be back into the
Why are you
Department of
homeless?
Corrections.
I thought you said you live with your
No,
mom.
I'm just saying, if I was to put too much pressure on the situation at hand, because I don't know how to deal with certain situations. At the end of the day, I think I'm trying my best.
Sir,
20 years ago, I would have been out committing crimes, breaking in these cars to make ends meet and having a job at the same time. But my train of thought is changing. I'm trying my best, Ms. DeSantos. I am.
sir, why are you not working full-time?
Actually, I can be working full-time, but, it's just, I have mental health issues that I deal with. I can't be around people all day like that. I have past traumatized, like there's certain things, I don't even like being in public. You let alone going to work. You think, have you been a gun violence person that, have you even dealt with that? No, you went to college. No, you are a judge. You have certain things that, the walk of life my walk of life was way different from each person in here.
Pause, sir, right now.
Yes.
No,
I am
no.
trying, but at the end of the day,
Sir, you're gonna pause right there.
Yes.
Because you do not know anybody's past history. You do not know what trauma somebody does or does not deal with, right? You do not know that.
exactly.
You do not know that. So do not make assumptions for anybody that's in this courtroom.
I'm just saying, we all have a different walk of life. We don't.
You don't know what walk of life I've had. You don't know what walk of life an attorney's had. You don't know any of that. So
Okay.
do not make assumptions.
But
Just
you
because
know-
people take different paths does not mean people don't
Well, my path.
understand what certain individuals go through. So don't make that assumption.
Your Honor, my path is much harder than anyone in here. That's what I'm just trying to say.
That's your opinion,
That
without
is
having all the
facts.
information.
Them are facts.
That's your opinion, not having all the information.
Okay.
Do you have something from your therapist, your treatment provider that says that you are unable to work full-time based upon your current issues?
There is nothing, no, I don't have that type of information.
Then perhaps you should have a conversation with your treatment provider.
Yes, ma'am.
Because otherwise, I'm going to expect that you're going to be working full-time so that you can move forward and have a different path than what you've been on.
Yes, I totally agree.
Well, now I'll say I'm confused, sir, because on one hand, you're saying that you have a full-time job, you can work. On the other hand, you're saying that you can't because of your circumstances and issues that are going on.
No, I'm just saying.
And now you're saying that you totally agree you should be working
No,
full-time.
no. I should be working full-time, but there's, at the end of the day, Ms. DeSantos, like I said, you have a different path of life. My path is different from yours.
That's your assumption.
Yeah. It's just certain things that I go about on a daily basis in a routine that I do. At the end of the day, I just didn't feel like it was comfortable at that time when this first started for me to be working full-time. Should I be working full-time now? Yes, I agree with you.
Okay, so then my question still stands, sir. Why are you not working full-time right now then?
I didn't put the effort in. To be honest with you, I didn't.
Okay, And let me clarify for you something, sir. Just because somebody is sitting here or somewhere else doesn't mean that there's not a similar path of life or some other path that somebody took. Just because I'm sitting here doesn't mean it was just thrown at me and here's where I am.
No, I'm not
So I
saying
just
it.
want you to be clear on that.
Yeah, I apologize the way I worded that, but I just, yeah.
We're adjourning this for 4 short weeks, sir, so you can get a full-time job. We'll adjourn this to November 12th. And we'll do it at 8:30 a.m. so that I'm presuming you're going to be working that day, so you can go right to work after you're done. So you haven't gone to any of your testing? If you were to test right now, what's in your system?
THC.
What else?
Oh, no, I don't do no, I go to work on the days I do.
That wasn't my question.
Nothing, Your Honor.
You need to bring in proof of your current medication, a medical marijuana card,
Yes, ma'am.
and you're to obtain full-time employment. And you're to test today, sir. You're not tested in quite some time, you are testing today.
Yes, ma'am.
I do not want to hear that you don't have $35. You must have $35 to test today because you haven't been paying for your tests. So you should have that. And you're not testing at probation, you're going to test at a testing facility.
Yes, ma'am.
We'll see you back on November 12th at 8:30 a.m.
Thank you.
And make sure you are also providing proof of your,
Counseling?
yes, your counseling. that-
I believe,
Can you please interrupt me, sir?
yes, ma'am.
To provide proof of your sessions. You don't have to necessarily submit proof of what you're discussing at your sessions, but proof that you're attending your sessions. What were you going to say, sir?
I believe my counselors, if I'm not mistaken, they send their notes to Ms. Shine.
I have,
Do you have them?
I have one, I
Okay.
have one dated October 1st. That's it.
Yes, okay, then that's the most current, yes.
Okay, well, if you say that you're going 3 times a week, sir, I should have something more current. Because it's October 1st was 2 weeks ago,
Yes.
okay?
Okay, thank you.
All right, thank you. Have a good day. Stop over to see Ms. Shine so that you can get your testing information.
Okay.
Let's go. So we're on the record in the matter of Nicole Rattleback, 24-9-232-549. And counsel, your appearance, please.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my clients. Time we consent to the matter being heard via Zoom.
All right, and Ms. Rattleback, your name for the record, please.
Nicole Rademak.
All right, and so today's date scheduled for a probation violation. You're currently on probation for operating while visibly impaired, as well as failed to report. And it's alleged that you tested positive for alcohol on September 16th. You tested positive for alcohol on September 24th, as well as cocaine. And counsel?
Yes, Your Honor. My client has been made aware of her right to a hearing that will not be necessary. She's prepared to not contest the results.
Please raise your right hand, ma'am. You solemnly swear. All right, and you heard the allegations that were placed on the record, correct?
Yes.
As to those allegations, how do you plead?
Guilty.
And counsel, if you can please run to your client.
Yes, I'd like to direct your attention back to September 16th and September 24th. Did you submit to an alcohol test and it reflected positive for alcohol? Is that accurate?
Yes.
And then also on September 24th, you tested positive for cocaine, correct?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea. Indicated probation violation is found based upon your plea of guilty. The technical violations 1 and 2 will enter. And counsel, the recommendation of your client being ordered to continue and complete all terms of probation, pay a $50 probation violation fee, attend outpatient substance counseling, and 45 days on the alcohol tether. As to that allegation, or as to that recommendation, counsel.
No objection to the outpatient substance counseling. Judge, I'd ask for consideration for either no alcohol tether at this time or potentially just a shorter amount of time. Otherwise, though, I believe the recommendation is are encouraging. We'd ask that it be adopted. Thank you, Judge.
All right, so Ms. Radaback, what's going on with this? I mean, you've been on probation for about 9 months and,
Yeah.
so now, closer to, well, 8 months, I guess. And now you've violated twice.
I've been doing really well, actually. I did have a few drinks. I've been dealing with my grandma's death. That's not an excuse. That's why I had the drinks. And I also came in sexual contact with somebody who was using cocaine. I did not know that until I tested positive and didn't know that could happen.
Okay, hold on, ma'am. Hold on. You want this court to believe that you tested positive for cocaine because you had a sexual encounter with somebody that used cocaine.
I did not use cocaine. I did not use cocaine at all. And I'm not lying.
Ma'am,
I understand that it sounds funny. Like I sat here and I told my probation officer the same thing. I have been doing this good. I would not come this far to mess up. I'm almost off of probation. I am not going to do anything to jeopardize what I have going on.
well, ma'am, let me just clarify something with you. I don't find this funny at all. And that there has been a number of testimony taken by this court from the toxicologist from Abbott Laboratories that it's ingested. The positive test is from ingestion, not from exposure or touching.
Well, I wasn't sure if it could come from saliva or anything, but I have not used it and I will not use it. I've come so far. I've been doing good. I've been doing good with my work, my community service, everything I'm supposed to be doing, I have been doing.
Okay, ma'am, I'm not suggesting that you haven't been doing well because in fact, this is your first violation. So it does appear as though you're doing well. And sometimes, right, there's slip-ups and the court's going to adopt the recommendation. This is a reasonable recommendation. The court's going to order you to continue complete all terms of probation, pay a $50 probation violation fee, attend outpatient substance use counseling, and 45 days on the alcohol tether. Because you tested not once, but twice, you tested positive for alcohol.
Okay.
And you're currently on probation for operating while visibly impaired. So the court wants to ensure that you're moving forward with that.
Okay.
So please email into Ms. Shine and she will get you that information. Email in please by 11:55.
Email her, I'm sorry.
Yes, email her by 11:55. If you're to test right now, ma'am, what is in your system?
Just my medication that I'm prescribed, which is Adipex, Celexa, and Abilify.
Okay. All right. Good luck to you, ma'am.
Okay, thank you.
Thank you. All right. We're on the record in the matter of Christine Matta, 24249.
Good morning, Your Honor. Christopher Shemke, appearing on behalf of my client who approached the podium.
Thank you. And ma'am, your name for the record, please.
Christina Matta.
All right, and today is the date scheduled for a probation violation. Ms. Mata's on probation for operating while visibly impaired by alcohol. And it's alleged that Ms. Mata tested positive on September 23rd of this year for alcohol. And counsel?
Your Honor, I've gone through my client's rights to have a hearing in which she could contest this. That will not be necessary. She's not going to contest the positive result.
You heard the allegations.
Yes.
As to the allegations, ma'am, how do you plead?
I would like to plead guilty.
And you understand the possible penalty as a result of your plea. And the recommendation in this matter specifically is for you to continue and complete all terms of probation, $50 probation violation fee, 45 days on the alcohol tether, 5 days jail, and it's recommended for that jail to be suspended. Do you understand that that's the recommendation?
Yes.
Knowing all that, you want to continue with your plea.
Yes.
And counsel, if you could please go to your client.
So I'd like to direct your attention back to September 23rd, 2024. Did you submit a test that you're not contesting came back positive for alcohol?
Yes.
Satisfied, Your Honor.
The court is also satisfied the plea is knowing, voluntary, and factually accurate. The court will accept your plea to the probation violation, indicate technical violation. One will enter And as to the recommendation, counsel,
Your Honor, I note that this is my client's first violation. She's done extremely well when she was on bond and otherwise has done very well on probation. I'd ask that the recommendation regarding the suspension of the jail be stipulated to. And then furthermore, Judge, based on the nature of this, I'm going to ask that potentially at this point an alcohol tether not be applied, but she does understand that any future tests obviously will have dire consequences if they come back positive. Thank you, Judge.
thank you. Ma'am, what's going on? You've been on probation since July 30th, and you made it just under 2 months. What happened?
I honestly don't know. When I went to go record, I think it was a diluted urine and that came out positive. I'm not sure. I know I was not drinking that day. I was at work that day.
Okay, well, ma'am, were you drinking the day before?
I had the wine, church wine, and that's the honest truth. And that's why I don't understand why it would came out positive. I had said maybe possibly the hand sanitizer that you use.
Nope, not possible, not at that level, nor is it going to go through as a positive test for that. Nope, that one, nope, check that off. And you know that there's alcohol in the church wine, I mean,
Right, absolutely.
when they do the blessing, they don't bless the alcohol out of it.
Absolutely.
So, you know, you really should,
That's why.
you have another alternative for that, but that would not get you to 937 nanograms per milliliter the next day. So.
Absolutely, I don't understand.
You consumed alcohol.
Okay.
So what is it you had to
But
drink?
I wasn't drinking that day. I wasn't the day before I might have, but I wasn't abusing it. It wasn't to the point where I was drunk. That's why.
Ma'am,
I-
pause. You recall your terms of probation, correct?
I do.
Okay, and it was you're not to possess or consume any alcohol or drugs that are not prescribed, correct?
Absolutely, yes.
Did it say that you're allowed to use alcohol as long as you're not drunk?
No, I'm
Did it
not.
say that you're allowed to use alcohol as long as you don't abuse it?
You're right, ma'am. You're honest, yes.
Okay, so stop circling around, and what is it you had to drink?
It was it was a Miller High Life because, and this is the honest truth too.
You keep telling me that, but
My
it
late
hasn't been
husband-
so far.
My late husband was his death date and his birth date are both in September. September is a very hard month for me, and to be honest, I did, because that was his drink. We had a celebration of life for him on that Sunday when we drank I consumed about 3 Miller High Lifes because that was his drink.
Okay, why didn't you just start with that?
I'm sorry.
I mean, ma'am, you're already caught. You're here.
Yes, that's why I came here to.
So I'm not sure why you're not taking accountability.
And I understand.
All right, here's what the court's going to do. The court's going to adopt the recommendation. The court's going to order you to continue to complete out terms of probation. $50 probation violation fee. The court's going to order 5 days jail. The court's going to suspend that jail. The court was considering not ordering the alcohol tether. However, based upon what seems to be your thought process and the lack of accountability that you want to take and the lack of
Your Honor.
honest statements that you've made to the court's going to order 30 days on the alcohol tether, not 45 days.
If I may, just if you could reconsider that, I would be I just know, and that's why I'm here to be honest. That's why I'm, my integrity is to be honest. And I did backtrack, but that's what my conscious mind tells me, just to be honest and tell the truth. And that's what I'm here for.
Okay, and you finally did after about the 4th try, so that's good. But no, the court's not going to terminate the alcohol tether. The court's going to order 30 days on the alcohol tether. So please have a seat over probation, and Ms. Shine will be with you shortly.
Okay.
Thank you.
So try to put on today?
Yes,
Okay.
I believe so. She'll chat with you and she'll give you all that information.
Thank you. Your Honor.
All right. And so we're going to go off the record for a moment. All right, and so we are on the record in the matter of the state of Michigan versus Marcy Gall, 241497. Detective, your name for the record, please.
Detective Sergeant Derek Gentry, the Riverview Police Department.
All right, please raise your right hand. Do the, solemnly swear for the testimony you're about to give this matter be the truth, the whole truth, and nothing but the truth?
I do.
All right, thank you, and you may proceed on the warrant.
Yes, Your Honor. On October 11th at approximately 11:02 p.m., Sergeants Jason Fell, Officers Christopher Schramm and Charles Bush were dispatched to 14 for a domestic dispute. The caller was a Blanche Kaplani who stated her adult daughter, the defendant, Marcy Gall, was out of control and intoxicated. Officers had previously responded to this location earlier in the day where it was alleged the victim and defendant had a verbal argument. Both parties were advised as they separated. And during that call, the defendant admitted to the officers that she had been consuming alcohol. At the second call to the location, when officers arrived, Officer Schramm and Officer Bush attempted to knock on the front door and received no answer. At that point, Lieutenant Sean O'Neill, who was working the desk and dispatch, attempted to call the victim back on the phone number that called 911. At this time, it is believed the defendant answered the victim's phone. At this time, the defendant stated to Lieutenant O'Neill that she could see the officers but would not open the door to the home. The victim, Ms. Kaplani, eventually came to the front door. Officer Schramm asked where the defendant was located, and she stated she was somewhere outside but did not know where. Officer Schramm at that time observed that there had been some sort of physical altercation between the defendant and Ms. Kaplani, as she had a small cut or scrape to her right wrist. Officer Schramm asked how that occurred, and Ms. Kaplani stated that the defendant had scraped her wrist when she attempted to grab the phone out of her hand when Ms. Kaplani stated she was going to call 911. She stated then that she believed the defendant ran out of the home. Officer Schramm and Officer Bush exited the residence and observed the defendant approximately 2 houses west of the residence sitting on the curb. Officers approached her and stated they wanted to speak to her. She got up and began to walk away from them, stating that she hadn't done anything. As the officers got closer to her, the defendant attempted to walk faster and flee the scene. Officer Schramm informed the defendant that he was going to detain her to conduct a domestic violence investigation, and he attempted to place her in handcuffs. At that point, she began to actively resist by pulling her arms away from the officers, while officers gave multiple verbal commands for her to stop resisting. Officer Schramm performed a takedown on the defendant in order to get her under control, and she continued to passively resist by pulling her arms underneath her and tensing up her body while on the ground. Officer Bush and Officer Schramm were able to get the defendant into handcuffs and escort to a patrol vehicle. While the escort, the defendant continued to resist officers by trying to pull away, push officers away from her with her body, and she was eventually put inside the patrol car for transport. Prior to that transport, the officers searched her person and located 2 cell phones on her person, one belonging to the defendant, to the victim, which was returned to her. During the transport, the defendant managed to slip out of one of her handcuffs and unbuckle her seatbelt. When officers arrived at the RIPD garage to bring her to the processing room, she again began to actively resist, and officers again attempted to handcuff her in the front during this time. Once she was handcuffed, she was brought into the processing room where she delivered a knee strike to Officer Schramm's leg. During this time, officers then moved her into the cell bay to place her into a cell. As officers were placing her into the cell and moving her handcuffs, she then kicked Sergeant Fell in the left thigh above the right knee. She was then placed in the cell without further incident. A warrant was submitted for domestic violence and resisting obstructing and assault on a police officer to the Wayne County Prosecutor's Office. Received a warrant back denying the domestic violence warrant, but she was charged, authorized for the assault on a PO, resisting and obstructing. She was then added on a habitual notice showing that in 2007, or I'm sorry, 2013, she was convicted of OWI third in the Sixth Circuit Court. And in 2022, probation violation, 2021 disorderly, and 2007 OWI, and 2013 another hindering and obstructing charge.
Okay, upon examination of the complaining witness, the court does find that the offenses charged were committed. There's probable cause the defendant committed that offense. And counsel, your appearance, please.
Good afternoon, Your Honor. Christopher Shemke, on behalf of my client. This time we consent to the matter being heard via Zoom.
Ms. Gall, your name for the record, please.
Marcy Lynn Gall.
Okay, I'm trying to find out what, Detective, her name's very familiar. And I don't know why.
Ms. Gall has been a resident of Riverview. Her maiden name is Kaplani. I believe she was in front of the court in 2021
Okay.
for the disorderly charge,
Okay.
which I believe was reduced down from another charge.
Okay. All right. And counsel, as to the arraignment,
Wait formal reading. My client stands mute.
the court will waive the formal reading. Ma'am, you do have the right to have an attorney. If you cannot afford one, the court will appoint one to represent you. And in fact, you've had an opportunity to meet with an attorney today, correct?
Yes.
All right, and the court's entering a plea of not guilty on your behalf, scheduling this matter for probable cause conference October 17th at 10:15 a.m. And counsel asked to bond.
Your Honor, my client's currently 52 years old. She is gainfully employed. She's currently working for a company called Susan, in which she's assisting with distributing campaign documentation. She resides with her mother. I believe that she does assist her, and that is in Riverview. I'd be respectfully requesting a low monetary amount, if not consideration for a personal bond. Thanks, Judge.
And Ms. Gall, have you ever failed to appear in court before, ma'am?
No, Your Honor.
Are you currently on probation or parole anywhere?
No,
Are you out on bond in any other jurisdiction?
no, Your Honor.
The matter out of, who was the complaining witness in that matter?
Hugh Gall, my ex-husband.
I'm sorry?
Hugh Gall, my ex, in 2013.
22.
That was my ex-husband, Hugh Gall.
And how long have you resided at the home with your mom?
Pardon? I'm sorry.
How long have you resided at the home with your mom?
Since around 2019, 20, so almost 5 years.
And is it her home or is it your home?
It's our home, so it's our family's home.
Ma'am, who is your name on the home?
Oh, I'm sorry. No, it's my mom's home, but basically, yeah, we might put it up for sale soon. Because it's a little too big for the two of us. But it's in my mom's name. I'm sorry.
Detective is to buy.
Well, Your Honor, this did originally start as a domestic incident. We were at the home twice. I think a lot of this, and judging by the defendant's past criminal history, is alcohol fueled, alcohol related. So we would ask that if she doesn't have a cash bond, that she at least be on an alcohol tether. I do have a few reservations with her returning to the home, but her mother did not want to go forward in this case. But her mother is elderly. Some sort of cash bond and a GPS alcohol tether that would monitor that. She did express to me a desire to get help for alcohol. I don't know if that's something the court would consider at this time.
Okay, ma'am, you pay child support?
No, I do not.
Well, it says obligations, $400 support a child.
That's just what I paid. They were asking about any expenses, so I was just mentioning, and I don't know why they put it like that, just what I paid to help with my children per month. But it's not child support.
How old are your children?
My son is 10 and my daughter's 16.
And where do they live?
They live with their dad and then with me on every other weekends due to me not driving yet. And my mom, which my mom and I are close.
That's the only reason that they reside with their father is because you don't have a license, or is it because of some other reasons?
That's the only reasons. We have joint custody.
All right.
In fact, her father tried to drop the charges from Royal Oak in 2021 because it was both of us. It was not just me, and he even paid for the attorneys, but it was not dropped due to what happened in 2013.
Okay.
Your Honor, the charge was, the domestic violence charge was dismissed. However, she was convicted of a probation violation because of the arrest. I believe, which was from the OWI.
All right. The court does have some concerns for the safety of the public as well as the safety of Ms. Kaplani based upon the allegations, as well as concern regarding the alcohol use. The court's going to order the following bond. The court's going to order a $10,000 10% bond with the following bond conditions. You are not to have any contact with Blanche Kaplani. That's phone contact, text message, email, social media, third party, anything of the like. Do not enter the premises at the home on Williamsburg with the exception of one visit to obtain personal belongings accompanied by a police officer. You're not to possess or consume any alcohol or drugs unless prescribed. You're not to possess or have access to any firearms and or any weapons. And you are to have an alcohol tethered to the Wayne County Jail. Those are the conditions of bond. And then we'll see you on Thursday at 10:15 a.m. Yes.
Can we please do a $750 bond? I don't have the 1,000. Please, may I do a $750?
Ma'am, this isn't necessarily a bartering opportunity.
I understand. But that's a lot for me not to be able to have any contact with my mom again. So may I please do a $750 because that's all that I have.
Detective, do you have a position on that?
I'm not against it, Your Honor. I mean, that would work out to what, $250 difference? I don't have an objection to that. She still would have to get the tether, correct?
That is correct. All right, the court will amend it to be a $7,500 10% bond with all the balance of the conditions.
Thank you, Your Honor.
All right, thank you. We're going off the record for a moment. All right, and we are still on the record in the matter of State of Michigan versus Jason Attar, 24275.
Good afternoon, Your Honor. Arthur Brand, P111126, appearing on behalf of Mr. Attar.
All right, answer your name for the record, please.
Jason Attar.
Okay, thank you for dressing appropriately for court. So today's date scheduled for sentencing after many pre-trials and adjourned pre-trials and set aside the plea and everything else that could have been thrown into this case. And let's handle the sentencing first, and then we'll handle the bond violation. And so, counsel, do you have an opportunity to review the report and recommendation with your client?
I have, Judge. And we have no additions, deletions, or corrections. Excuse me. However, my client is asking that the court consider community service as opposed to workforce because he works every day of the week. He works for a company called Centimark, excuse me. And he's a supervisor and he can't get off work. So we're asking the
He
court.
doesn't get any days off of work. He works 7 days in a row.
7 days a week, about 24 hours. I'm sorry.
He doesn't get any time off of work.
That's
How is
what-
he supposed to do community service then?
Well, at least he can do it on, in the evenings or times that the court would not have workforce.
I'm sorry, go ahead, counsel, you can continue.
No, that's the only addition or correction and that we're asking the court to follow the balance of the probation recommendation, Judge. Oh, and I want to indicate to the court, just so the court knows that the lady in the back happens to be his mother. It's always a good thing to have your family with you.
We'll note after hearing from counsel, reviewing the report, the recommendation, the court does find there's reasonable grounds to support MCL 769.5. The court will also note that the following sentence is in the best interest of justice and is reasonable and proportionate to the seriousness of the matter and the circumstances surrounding Mr. Attard. In light of the legislative guidelines, and the court's going to order the following. 18 months probation, you're eligible for early discharge, and I'll go over that shortly. You're not to violate any criminal law of any unit of government. You're not to leave the state without the consent of the court. You are to report to your probation officer as often as your probation officer may require, in person, writing, or virtually. You notify your probation officer immediately of any change in address or employment status. You are to enroll and participate in outpatient substance use counseling. The rehabilitative goal for that condition is so the court can monitor your progress in maintaining abstinence and sobriety. I'm sorry, that's the rehabilitative goal for the no alcohol or drug use unless prescribed. You'd be subjected to Arraignment testing. You have to participate in outpatient substance use counseling. The rehabilitative goal for that condition is so that you can have assistance in providing coping mechanisms so you can maintain sobriety and prevent relapse. You also have to enroll in the MAD Victim Impact Panel. The rehabilitative goal for that condition is to further increase your understanding of the danger of driving while under the influence and the consequences of such behavior. Our workforce for personnel reasons, and so the court's going to order community service, 100 hours of community service. The rehabilitative goal for that condition is to give back to the community. The court's going to also note no weapons to ensure the safety of the community would be the rehabilitative goal for that condition. And that I think you've already agreed to, but you're going to forfeit the brass knuckles. You will not be receiving those back into your possession. Any questions regarding the conditions?
No, I don't know, Judge, thank you.
All right. As to the fines and costs on operative visibly impaired, that's a $300 fine. $100 screening and assessment fee, $900 supervision oversight fee, that's $50 a month at 18 months. Since you're eligible for early discharge, some of that money may not be due. $300 for the cost of prosecution, crime victim assessment fee of $75, justice system assessment fee of $50. A total of $1,725 on that charge. As to the open alcohol, $100 is the fine. I'm not charging a screening or oversight fee because you're already being assessed that on the first count. Cost of prosecution, $100. $75 crime victim assessment fee. Justice system assessment fee of $50 for a total of $325 for a total of $2,150 between both matters. You did post a $500 bond. Do you have any other money to pay today?
Yes.
If you don't have any other money to pay today,
No,
so this matter's been pending since.
No, yes, I have.
You said-
I'm gonna pay it all, Your
He
Honor.
said yes, he's got.
Oh, I'm so sorry. I heard no. I'm sorry. Okay, so we're going to hold back $450 of that. Okay, so let me just do that math. So you have $2,150 and you've already paid we're applying $500. And then that leaves a balance of $1,650. And then we will back out $450 because that's half of the cost of the probation. So that would be $1,200 as the balance. And you have $1,200 to pay today, sir? Okay. So the court will note then $1,700 total we pay today.
1,700 today?
When we apply the bond plus the $1,200 out of pocket.
Oh, okay, yes, ma'am.
Okay,
Yes, ma'am.
because then $450 may not end up being due.
Okay.
Okay? All right, and then I did indicate you're eligible for early discharge so long as all of the following have occurred. You've completed at least half of your original term of probation. All probation requirements have been completed. You've had at least 3 months without any violations. All monies have been either paid in full or you've made a good faith effort to making full payment.
Yes, ma'am.
Okay? All right, now, remember, after we handle the bond violation, you're going to go over to probation. So please raise your right hand as it relates to the bond violation. You solemnly swear or affirm the testimony you're about to give in this matter to be the truth, the whole truth, and nothing but the truth.
Yes, ma'am.
Okay. And so this is alleging, counsel, that your client tested positive for alcohol on September 19th of this year. And what are we doing with the bond violation?
I think he wants to plead guilty.
All right, sir, and you heard the allegation that you tested positive for alcohol on
Yes.
September
Yes,
19th,
ma'am.
correct?
Yes, ma'am.
Ask that allegation, how do you plead?
Guilty.
You've gone over your advice of rights with your attorney, and you understand you do have the right to have a contested hearing, correct?
Yes.
And you understand the possible penalty as a result of your plea.
Yes.
This court could revoke your bond, this court could send you to jail, this court could give you an order of fine, there could be a plethora of in-between options. Do you understand that?
Yes, ma'am.
And knowing all that, do you want to continue with your plea?
Yes, ma'am.
Has anybody promised you anything, threatened you, or coerced you in any way for you to enter into a plea?
No.
Counsel, if you can please pardon your client.
On the day and date in question, were you drinking alcohol?
Yes.
What'd you have?
I just had a few beers at the house.
And did you know it was a violation of your bond?
Yes.
Thank you.
All right, and the court does find the plea as knowing, voluntary, and factually accurate. The court will accept your plea per the plea agreement. And, counsel, what should I know before I,
Well, you have all the facts. Actually, you have all the facts. You have the probation report. Excuse me. I think what the court needs to know more than anything else is that as you said, we've had many court hearings in this case. And my client has always been compliant with coming to court. So it wasn't like a question of him not showing up on some of these occasions. It was kind of a long and protracted matter, which we brought to a conclusion. So my client, I think, is a good candidate for probation. And I think that he won't be doing anything like this again. I think he's learned his lesson. It happened once. He's been tested many times. And it happened once. Not that it happening once is any kind of an excuse, but it only happened once. And his mother's here, as I indicated earlier. So that's always a good thing in a situation like this.
so, sir, what gives?
I've been very stressed. Like he said, I don't ever get a day off besides coming to court. It's been dragged out. I have currently 3 of my friends had died that week. 2 had died in the car accident. 1 had dropped a mower on himself, redoing the mower and all that underneath. So after the 3rd funeral I went to, I just kind of lost it. My ex-girlfriend I'm trying to kick out and won't leave because I have to get her evicted. And so that's been an ongoing eggshell walk at my house, nonstop arguments every day. And there's nothing I can do about that. And it's all this just kind of kicked on at once and it just overwhelmed me. And I sat in bed and I just had a few beers and that's all I did. And I couldn't get out of my head. And that was the end of it. And that's, I'm being 100% honest with you. I just needed to try to relax and just unwind a little bit, and that was it. My life's just been very hectic, and it does not stop, and it's still not stopping with this eviction, and it's just a nightmare with her, and that's it.
Okay, sir, I can understand when there's a lot going on, and I can understand when there's a lot of sad events,
Yeah,
right? But there needs to be another way to go about with your coping mechanisms.
right, I know, and I'm not saying that it was for a good issue or anything like that. I know I didn't leave, I didn't drive, I knew not to do none of that stuff by any means. It was a couple of beers, and then the next day I got tested, and I call every morning at 6 before I go into work, just so I can get there and go in the morning just before everything, because I sometimes don't get off until past 8 o'clock. It's whenever the day's over for me. It's not that I have a set time. It's just, it just all finally just kind of hit me at once, and then leaving the 3rd funeral was seeing people, and I mean, these are people I grew up with, and I'd seen every day, if not every other day. We were planning on going salmon fishing, and that whole thing just got destroyed, and it's people now I'll never talk to again, and it just really ate me away. It still does every day. I mean, it's just.
So how do you, and I apologize for your loss, sir, so how do you cope since the 19th?
I've just been trying my hardest not to. I mean, I'm not addicted to alcohol by any means or anything like that. I've just been trying to keep busy. I bought a boat, so I've been working to finish that, and just for the winter project, just to have something to do, just trying to keep my mind at ease instead of having to sit there. It doesn't help with the ex at the house. It's constantly just going at it with me while she's drinking, and I'm just sitting there having to deal with it. There's nothing I can do but to have to deal with it because of the eviction notice, and that should be next month sometimes. It should be at the final, because she refuses to leave with anything. My mother can contest with you not to bring her into everything, but it's just been a nightmare.
Well, sir, hopefully, you're going to get some days off next summer, otherwise I'm not sure why you bought a boat.
Yeah, well, I try to like PTO time if I can, but that's it's few and far in between. I run a 5-man crew, and it's just been.
All right, so here's what the court's going to do. Order 5 days jail. I'm going to suspend that jail. All right?
Thank you.
If there's a violation of probation, sir, that jail's back on the table. Okay?
Yes, ma'am.
All right, please have a seat, open probation, and something will be with you shortly, okay?
Thank you very much.
All right, good luck to you. All right, let's go on the record.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is absolutely an interpreter.
I need an interpreter when I cannot express myself somehow.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're gonna start bringing people in for people to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
Come and go, so let this feeling grow. I'm sitting up here, I'm the one that needs a drink.